Back in January, the news announced that the U.S. Supreme Court said Texas could no longer lay razor wire at the border, but they keep doing it. What the hell happened? Hello, all you beautiful people. World's Okayest lawyer here, busting out my Abraham Lincoln tank top. Promise it will make sense later. Folks are arguing like crazy that Texas, particularly Governor Abbott, is ignoring the Supreme Court. Some people have argued, such as yours truly, that it is their world's okayest opinion that the U.S. Supreme Court is risking another Dred Scott opinion by continuing to tell Texas they cannot protect their border. So what did the Supreme Court actually say? First, this is from case number 23A607, Department of Homeland Security et al. V. State of Texas. For those of you that have heard me before, I hate that we use Latin in court proceedings. Et al. Just means and all. Lawyer in courts. It's legit only 2 more words to use English. We have to do better. Justice Alito said, and I quote, "The application to vacate injunction presented to Justice Alito and by him referred to the court is granted. The December 19, 2023 order of the United States Court of Appeals for the Fifth Circuit case number 23-50869 is vacated. Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh would deny the application to vacate the injunction." That's it. 55 total words. That's the entire opinion. So what the hell happened? The federal government filed for an injunction against the state of Texas to allow them to cut razor wire along the border. In military terms, it's called C-wire or concertina wire. If you have ever been to a military installation, then you have likely seen C-wire. Movies also show it. In addition, sometimes you will see police use it in the U.S. for mass stops. The federal government did not agree with the Fifth Circuit's decision that prevented the federal government from cutting the C-wire and appealed the injunction to the U.S. Supreme Court. Overturning the injunction was on a 5-4 vote, but SCOTUS, Supreme Court of the United States, if you've not heard that before, did not issue any reasoning on the case, as you already heard. So, if there is no reasoning on the case, then we have to look to see what the federal government actually filed with SCOTUS. In the supplemental memorandum regarding emergency application to vacate the injunction pending appeal, the federal attorney outlined the background and status of the case. On December 19, 2023, the Fifth Circuit issued an injunction against the federal government, preventing them from damaging, destroying, or otherwise interfering with Texas's concertina wire fence in the vicinity of Eagle Pass, Texas, except if necessary to address any medical emergency as specified in the temporary restraining order previously issued by the district court. The Fifth Circuit then noted that federal agents already possess access to both sides of the fence, to the river and bank by boat and by further inland side of the fence by road. On January 2nd, 2024, the government filed an emergency application to vacate the injunction pending appeal. Texas filed its opposition on January 9th, and the government filed its reply on January 10th. Hours after the government's filing, they learned that Texas had continued to lay more C-wire along the Texas border, including in federal staging areas. Federal agents also attempted to launch a boat, and Texas denied their access to the area. The federal government argued they should be able to cut the C-wire in the event of an emergency at the border. The federal government argued that Texas was escalating actions along the border while the case itself is continued to progress through the courts. So what does the injunction actually say? It merely says that the federal government can cut wire. There is nothing in the opinion of the court that says Texas cannot go right behind them and lay more wire. Earlier, I mentioned the Dred Scott opinion. I think this opinion is going to be really important for SCOTUS. I don't think it's an important opinion based on any particular law, but it is important that SCOTUS does not get ignored again. What do I mean by that? Back in 1857, SCOTUS held in Dred Scott v. Sanford that the U.S. Constitution did not extend American citizenship to people of Black African descent, and therefore they could not enjoy the rights and privileges the Constitution conferred upon American citizens. The Supreme Court essentially said owning slaves is constitutionally protected by the Fifth Amendment, that slaves are chattel because of the importation clause under Article 1, Section 9, and the fugitive slave clause, which references Article 4, Section 2. Slaves do not have privileges and immunities as given by Article 4, Section 2. If Congress does not have the power to create slavery, then they do not have the power to prevent slavery. Essentially said slaves today, slaves tomorrow, slaves forever. In the Articles of Confederation, if anyone wants to change the law, amend the Constitution. So, if you have not heard that before, we previously were not a constitutional government. We were under an Articles of Confederation, and we actually had to change it. So that's what that is pointing out to. So under Article 9, Section 5, Congress should have the power to agree upon the number of land forces to be raised and make requisitions from each state for its quota in proportion to the number of white inhabitants in such states, which requisitions should be binding. Article 4, whether Black men and women were citizens of their states and entitled to the privileges and immunities of citizens in the several states. African Americans can't be citizens per the definition of the Constitution, and therefore can't achieve diversity for federal court jurisdiction. In a limited view of Article 4, Section 3, to known territories at the time of the Constitution. So the Territories Clause, Article 4, Section 3, struck down the Missouri Compromise of 1820, stating that the federal government had no legitimate constitutional power to limit the spread of slavery to new territories, and essentially ended any hopes of a peaceful political compromise. The power is given in relation only to the territory of the U.S., that is, to a territory then in existence, and then known or claimed as territory of the U.S. The Fifth Amendment. So when arguing for that, they stated that it held that slave owners had a substantive right under due process clause to own slaves and to carry their slave property into any federal territory, and that the national government lacked power to restrict ownership of slaves in the territories. States get to decide for themselves whether slavery will be legal, and it again diverts the Missouri Compromise. So in concurring, and that, by the way, that opinion was written by Justice Roger Taney, but in the concurring opinion, Justice Nelson discussed the 10th Amendment, that state sovereignty cannot be impeded by extraterritoriality. They are distinct and separate sovereignties. In the dissent, Justice McLean stated that the state of slavery is deemed to be a mere municipal regulation founded upon and limited to the range of the territorial laws. The prohibition of slavery within the Missouri Compromise followed the ordinance of 1787. Justice Curtis, also dissenting, argued that Article 4 of the Articles of Confederation gave citizenship to emancipated slaves, that Article 1, Section 8 gives Congress the power of naturalization. There were 5 of the 13 original states that recognized free blacks as citizens, and that people born in the country are citizens. So, as you can tell, nothing to do with, what's going on. It's a pretty terrible opinion now that you really hear it, especially in 2024. And and it makes sense when you start hearing the justices arguing for state rights, because it's exactly part of the reason why the South seceded, obviously going along with slavery as well. So Lincoln responded to the Dred Scott opinion by saying, in part, "I think the authors of that notable instrument intended to include all men," and notable instrument means the Constitution. But they did not intend to declare all men equal in all respects. They did not mean to say all were equal in color, size, intellect, moral developments, or social capacity. They defined with tolerable distinctness in which respects they did consider all men created equal in certain inalienable rights, among which are life, liberty, and the pursuit of happiness. This they said, and this they meant. They did not mean to assert the obvious untruth that all were then actually enjoying that equality, nor yet that they were about to confer it immediately upon them. In fact, they had no power to confer such a boon. They meant simply to declare the right so that the enforcement of it might follow as fast as circumstances should permit. They meant to set up a standard maxim for free society, which should be familiar to all and revered by all, constantly looked to, constantly labored for, and even though never perfectly attained, constantly approximated, and thereby constantly spreading and deepening its influence, and augmenting the happiness, the value of life to all people of all colors everywhere. The assertion that all men are created equal was of no practical use in effecting our separation from Great Britain, and it was in the Declaration, nor for that, but for future use. Its authors meant it to be, thank God, it is now proving itself a stumbling block to those who in after times might seek to turn a free people back into hateful paths of despotism. They knew the proneness of prosperity to breed tyrants, and they meant when such should reappear in this fair land and commence their vocation, they should find left for them at least one hard nut to crack. These words ultimately led to the Civil War, where the Dred Scott opinion was rightfully overturned by the 14th Amendment during Reconstruction. Essentially, Abraham Lincoln argued it's only the Supreme Court, and he kind of just did whatever he wanted. So that's why I bring up this case. Essentially, SCOTUS was ignored by the President of the United States. There's an inherent risk that even if the federal government ultimately prevails against Texas, that Texas will ignore the opinion. Will the office of the presidency, as commander-in-chief, deploy another National Guard unit under Title 32 along the U.S. border to do battle with Texas military and law enforcement officials? Under Posse Comitatus, the president cannot deploy active duty soldiers under Title 10. That just seems like too large of a risk from all sides. I would venture to guess that SCOTUS will have a hard time threading this needle, should they even accept the case on appeal. Yes, SCOTUS can deny certiorari, which just means a review of higher court. Damn Latin, can't stand that stuff. If we know anything about SCOTUS, they do not want to lose power again. So wrapping this up into a bow, SCOTUS merely allowed the federal government to cut wire. Nothing in their opinion said that Texas could not lay sea wire right behind it. In fact, the Supreme Court gave no reasoning at all to go along with the emergency filing. There is a huge risk that SCOTUS will be ignored again, just like they were with the Dred Scott opinion, should they even take the case up on appeal. It is also unlikely that the president would perform any physical enforcement action against Texas, leaving SCOTUS with words with no power. So, like what I had to say, please be sure to follow me on social media, wherever you saw this posted. I cannot thank you enough for listening to what my world's okayest opinions are. Lastly, it costs $0 to be kind. It's the best money that you'll ever spend. Until next time, beautiful people, be well. Peace.